for trademark success. With me today, I've got Reet van den Ende, and we'll be co-presenting this this webinar for you, talking really broadly about trademarks and what you need to do to be successful in trademarks in Australia. Thanks, Reet, for agreeing to come on today and guide us through these top 10 tips after lots of trademark applications.
My pleasure. No, we get a lot of inquiries, at least around how to set up a brand as strong as possible. So I thought it might be good to share tips and tricks to try to get as much of a strong, secure trademark portfolio.
And lots of, we realize that lots of lawyers and business owners don't know a lot about trademarks. Certainly before I registered trademarks, I knew sort of broadly what they were, but I didn't realize how powerful they were and how much they were smartly used by really good businesses to protect their intellectual property, protect their brand, protect their net worth, and protect them from competition and attack from others.
Exactly. I think a lot of business owners also think trademarks are only relevant when you have a massive business on a large scale or you've been trading for a very long time. But we see a lot of cases where it's actually so important to get your trademark protection going at the beginning. And while you're setting up your business and while you're choosing your brand, really that's the moment that you want to look into securing your trademark rights to make sure you're not infringing on anyone else's trademark rights, but also just to make sure that you can move forward and no one else will be able to start using the same brand while you're trying to gain reputation in a marketplace.
And,
so yeah.
And I've found too that lots of small businesses, people don't realize that the smaller the business, the more vulnerable it is, just like a baby cub. And when businesses, smaller businesses and startups are sort of saying, oh, I'm just starting out, do I really need that? I think the answer really is, yes, you need it more than what, for instance, a large international organization might need it, because a large international organization will have lots of resources and will go to the ends of the earth and have lots of prior existing rights. But even they realize the power of registered trademarks and will register trademarks in jurisdictions before they even trade in them. So lots of people just don't understand. And even small businesses, as we've sort of seen, a number of cases have been able to fight off large international US, mainly US brands from coming to Australia. And all because of the power of that registered trademark, not just their common law rights, but that registered trademark, and for a long period of time, the longer the better, prevents even businesses that are 400,000 million times as big as them from coming in and trading in Australia. So that's the kind of power that they have. And I think smaller businesses are starting to really wise up to that fact, and with intellectual property generally being, what they call the oil of the 21st century, and you think of all the major businesses out there now, they're moving from large car manufacturers or oil and gas and General Electric, General Motors, etc. They're now moving to large tech companies. The top companies in the world now really are tech companies, and that permeates all the way down from top now through the rest of the business landscape. Let's crack on through that. We've got a lot to get through. We're going to try and get through all these top 10, but it's going to be more of a conversational sort of style piece. We've obviously got some lecture slides for everyone to guide us and to make sure that you can kind of see us as we go through this. But we will add, and I'll be chiming in from time to time with more stuff as well too. We wanted to make a bit of an interactive CPD so that it's not the typical boring CPD. Great. So let's jump in. So tip number 1 out of 10: understand what is a trademark.
It sounds so basic, but it's really the foundation of starting to succeed with your trademark protection. And if you're more into the advising of others about trademarks, it's also really important to have them understand where it all starts. So really getting trademark registration is all about getting an exclusive right to the use of a brand and being able to stop others from starting that use in the marketplace once you've registered your brand. A trademark registration can be for any type of sign. It can be words, slogans, taglines, a logo, just an image. It can be a combination of all those things. I think a lot of times it gets forgotten that it can actually also be quite special branding features like sounds or shapes, movements, colors and smells. And they're a bit more unusual to be reflected on a trademarks register, but you definitely see it in some big brands. I know M&M has a movement trademark for their M&M, how do you say, their M&M little figure that moves around, yeah, in their advertisements. And Coca-Cola has trademarks for their shapes of the Coca-Cola bottles. So it's definitely something that people add to their trademark portfolios. So businesses that see a kind of a feature like that as something that really adds to the distinctiveness that they hold in their brand. And that's really the basics. Yeah, that's really the basis of trademarks.
Tiffany does their little their boxes, the little pouches. They've registered trademarks for the little pouches, the Tiffany pouches, the color, the Tiffany teal, all this sort of stuff that's used to identify their brand and distinguish them from others in the market. So what sets the business aside? And obviously they've these types of businesses work really hard on color palettes and the schemes and how stuff is portrayed. Like obviously there's different types of intellectual property protection you can get around designs, but some of these businesses will also try and register trademarks for this type of stuff as well. That Coca-Cola is a really good example. That the shape of the old 50s, 60s, the bottle, that's a really unique shape, and anyone using that shape, they're saying that this is a trademark of Coca-Cola because it identifies our goods and our goods that we sell. And if someone was to come along and use that same shape of that bottle, then that would mislead and deceive the market and confuse them as to who the origin of those goods and services are.
Yeah, and that's the beauty of intellectual property in that sense as well. It all complements each other to protect a business and its appearance in all types of features. So even for design, you can get a trademark, you can get a design registration, perhaps you can patent some kind of feature of a product or a thing. But it all works together to protect a business as a whole and its branding and its distinctiveness. And trademarks are the same like that. Anything that will be adding to the capability of setting you apart from competitors or other traders essentially can be registered as a trademark. Of course, it's still a case-by-case scenario, but that's the basic rule when it comes to trademarking.
Nike, as an example, the swoosh. Now, you remember how they used to use Nike and the swoosh together?
Yeah.
Now they just dropped the Nike. Well, they have done for the last 5-10 years. But they've just dropped the Nike completely because now the swoosh is synonymous with Nike. It's synonymous with the brand.
Yeah.
So you've got, and then Just Do It as well. So each of these unique pieces of intellectual property, the brand, the Nike, the swoosh, Just Do It, they're probably all sort of getting close to having exactly the same value as each other. Which is incredible that a tick
a very strong portfolio. Yeah,
synonymous. And there's a great story with the lady that designed the swoosh, and I think they ended up giving her some shares because they thought that the $50 that it cost to design the logo was just so unfair.
Paid well off at the end. Yeah.
Yeah, I think she ended up doing very well out of it.
Well, I guess that sort of brings us to point 2, choosing a strong trademark. I'll just forward the slide while we're at it.
Yep.
Because Nike did such an amazing job at choosing distinctive trademarks. There were, at least the word Nike is unique. It hasn't appeared before in relation to the products that they are providing. I believe it's an invented word, but I might be wrong there.
Oh, Nike, the goddess.
Yeah.
I think goddess of victory.
Oh, yeah, correct.
Yeah, but never used in relation to shoes and apparel before. That's sometimes you can have a unique, it might be something that's synonymous out there in the market, but or it's something that's not commonly used, but it's out there, but just not in relation to the goods or services that you're selling. That maybe just, oh wow, that's I would never have thought to associate those two, which means you've got a higher chance of success of getting a registered trademark if you're using a name, even if it's not technically unique, but it's unique over the goods and services that you want to claim for. Like something like your local plumber, like that's going to be that's going to be tough, if you're going to be just asking for plumbing services, if not impossible.
I know, but unfortunately, it does happen a lot. I mean, it's appealing to choose a trademark, especially as a startup business, or for many kinds of businesses, it seems very appealing to choose a trademark that just describes exactly what you provide, what kind of products you issue, or what kind of services you're providing. But then when it comes down to protecting your brand and being distinctive, being able to set your business apart from those of your competitors, that's where a descriptive trademark has its downsides. And especially once you're growing your business, it really becomes so relevant to be able to invest in your brand without having to deal with that many other people using the same or similar type of brand. Unfortunately, that comes with a few downsides. So yeah, having an invented or a known word that's used in an unusual way, any type of unique trademark that is easy for people to remember and to relate to the business that you're conducting. That's of course all very good elements about choosing a strong brand, and definitely on our do list.
Google's a great example of that, right? I mean, and that's definitely. If you're looking for world domination, you really need to come up with so novel and unique that that no one has it before, and then go after it.
And keeping that trademark as a unique mark comes with its difficulties too when you grow like Google. We've done a feature on that on our website, I'm pretty sure, about how a trademark can become generic. So having a unique trademark and make sure you continue using it and educating your customers to use it as a trademark. It's a very niche business to make sure that your trademark actually keeps that unique effect on consumers once you grow that big as Google. But yeah, that's for another time.
The more you use it, the better, right? So using it on all your materials, like for instance, we're using it right now on the top right-hand corner of the lecture slides.
Yeah.
Like anything that you put out there that you're marketing to people, that's all important to make sure you've got all these brand assets that you use a lot and can show trademark examiners if you ever need to provide evidence of use later. If they've got an issue with it, you need to overcome some objections with lots of evidence of use over an extensive period of time. Then you can show them, hey, this is us using our branding at this event. This is us using our branding on these presentations and this and anything where this email went out to our thousands of people on a database with a branding and logo on it, or the tagline that you're looking at trying to register. So the more the merrier.
The bigger your outreach is. Yeah,
your Facebook page and all your social media handles, using these trademarks a lot. We're probably skipping ahead here. Yep.
Oh, it's difficult not to. But yeah, we should probably go ahead to the next one. Let's see. Yeah,
Yeah,
just
three-letter acronyms. Three-letter acronyms is definitely one that the that IB Australia has had some issues with TLAs.
yeah, they pick on it. They pick up on it quite easily nowadays. That as soon as something becomes generic in a marketplace as an acronym, or has a formal meaning, I guess, it will be difficult to trademark a three-letter acronym. Well, if it's a 5 or 6-letter one, it might be a lot easier. It depends on the situation.
It's not completely out, but just like
no, it might just prove a little more difficult.
Yeah, and same with even some of these, with I mean it's best to have a strong trademark, but it doesn't prevent us from giving it a go with, and maybe even in conjunction with other, to make a composite type logo with lots of stylistic elements to at least get them some protection for the trademark, even if we can't get the words just quite yet, and they might need 10 years in the market, 15, 20 years ultimately if they're going all guns blazing.
Yeah.
Yeah, don't use anything with Apple in it, because you'll get a letter from Baker and McKenzie. Even anything at all. Same with Red Bull, same with Toyota, any of these really large companies. Ford is another example. They're very, very, very robust in their prosecution of the trademarks. They really want to make that anytime someone registers trademarks for these types of for these businesses, like here's another example with Style Kia. They'll pick up on them, and they'll make sure they'll make the investigations first, and you'll have to justify why they shouldn't oppose you, and they're very proactive in terms of their enforcement of their trademarks, because they're very protective over their brands.
Yeah, which goes hand in hand with growing your trademark reputation and having that ability to distinguish your brand from those of others. Part of growing that reputation is, of course, by making sure no one else is diluting your brand reputation in a marketplace.
Like that's slide 10.
Yeah,
registering your trademarks. That's a really important step.
Yeah, and it's one that most don't realize is important at the beginning, and it might only be clear to them that they need to register their brand once they run into an issue with someone else starting up a similar business under a similar name, and by that time they realize that it would have been handy to have those trademark rights already. Of course, then we can still start that process and see what options there are. But at the end, registering your trademarks at the beginning, or as soon as you're aware of the strength of having registered trademarks, is always a great idea.
I think the main thrust of it is, when would now be a good time? So our sort of advice constantly from to clients is, as soon as you're settled on that name, as soon as you're settled on that trademark, on that logo, as soon as you're settled on that tagline or hashtag or whatever it might be that is really novel and unique, and think about it from this perspective: would you care if someone came along tomorrow and started, and used the same name, or used the same or similar logo, or used some part of your name that was too close for comfort, that was confusing others? Then the answer is yes, you should trademark that, and you should do it as soon as possible, because the process takes 7.5 months at the moment, approximately, to finally get the registered trademark. Obviously you accumulate registered rights from the backdated to the date of the filing, but you don't get your certificate for 7.5 months later.
Yeah, it takes time.
When someone comes to us and says, oh, this is person infringing on our marks, and we need to trademark this stuff now, we have to break the news to them that, well, yeah, at the moment, you still have prior existing rights, and that's ultimately usually the highest power you can have, but not having the registered trademark is just so much more fundamentally easier to prosecute, because you can avail yourself of the Trademarks Act.
Yeah.
We don't have to prove reputation in order to be a winner. But if you're relying on the Australian consumer law under misleading and deceptive conduct and tort of passing off, you know, you kind of you have to prove your reputation in the market that, you know, and that people are going to be deceived. Whereas under the Trademarks Act, there's none of that. They don't, you know, there isn't the case of, oh, we'll you know, show us why your reputation is so big in the market that you're infringing this, you know, this person is infringing your intellectual property rights. And that's the beauty of trademarks and registering trademarks under the trademarks.
Exactly. Once you have that certificate of registration, that's the base of your rights, according to the Trademarks Act. So reputation actually is almost irrelevant. It's all about just the extension of your rights and how you're applying them and how far they can go. And that decides how much reach you have and how easily someone else infringes your rights. But
and also too, if you know, in an ideal world, you register the trademarks as soon as you're set on them, preferably before you go out to market. So you've got a filing date, you know, just you know, on the day that you're going out to market, you file registered trademarks as soon as you possibly can. You know, just to get that filing date. That's really important, to get that date from IP Australia. Then you've got something on the register that's time stamped and date, you know, and no one's going to take that away from you.
Yeah, because once someone else comes in before you.
After that. And because it's a first to use, you know, system that we have, but this sort of possession being 9/10 of the law, you know, this, you know, I'd much rather have the trademarks than somebody else coming in and trying to register them underneath them, and then you're having to, you know, make applications for, you know, for to strike them off for bad faith or whatnot, which is never.
Yeah.
You know,
I mean, essentially, IP Australia doesn't check what use is already out there in the market, so it just complicates things. If someone else already has tried to obtain trademark rights successfully or still pending before you, it just means that, you know, more action has to be taken, even though the law will back you up in that sense. If you have prior rights, it doesn't automatically refuse anyone else's rights.
Much rather be coming from a position of having the registered trademark and being able to write the cease and desist letter to the enemy saying we have a registered trademark. Plus, we also have all this other stuff as well, which is, yeah, and then, you know, we talk about misleading, deceptive conduct, passing off, etc., etc. But at least we're coming from that position of even more strength. We've got the registered trademark for this, and the conversation, you know, when we've advised clients that have received that type of correspondence, if the other side has a registered trademark or if they do not, sometimes can be very different, that conversation. But, you know, if they've got a registered trademark and they're coming from that position of power and you're looking at this and advising them, and you're basically saying, oh, you're in trouble here. We need to get you out of this immediately. And the advice, you know, sometimes will be, you need to rebrand immediately. We need to get you, and we need to extricate you from this before they take you to the federal.
Yeah, exactly. And coming back to the slide, we do see the mistake often that some clients can think that by having registered a company or business name, domain name, or social media handle even for a certain brand, they have those rights already. But it really takes a registered trademark to be able to get those exclusive rights to a brand and monopolize your brand use in a marketplace in that sense.
Unfortunately, because it takes, and I'm going to labor on this for a little bit longer, because it takes that 7.5 months to register the trademarks, you know, getting it done now means that in business land, you know, 6 months goes like that, and then you know you suddenly have a registered trademark. Lots of our clients go, oh wow, that was fast, because I've got to, you know, even though it was still the same amount of time. Things move fast in startup and small business landscape, or in business generally. You know how fast the years fly. And then you got the registered trademark, and then you've got it for 10 years. But you know, it's really difficult when a client comes to us and really ought to have registered their trademark, you know, 6 months, a year, 2, 3, 4, sometimes 5 years ago. And now they're having to register the trademarks and pull themselves up by their bootstraps in order to register the trademarks. then have to make a decision about whether we write the cease and desist letter to them now or after the trademark is registered, because obviously once you put the other side on notice that the trademark is in the process, they can potentially oppose the trademark and cause all sorts of problems. So this is the whole like stitch in time saves 999,000 thing that I always say. Just better to get it done now and do it right. Stitch in time will save that down the track. And obviously, and two, it can be really distracting, really annoying, very costly, and attacking the business at its fundamental level, its brand. It can be really shaking, especially for a small business that suddenly they may have to be thinking about the R word, not recession, rebrand. Which is really tough to swallow, because they spend all this money, time, energy, and effort, and have a really big association with the brand, only to be told, oh, you're gonna have to change it.
Yeah, exactly. Well, let's look at our next point. Right?
Yeah.
Consider which brand features to secure.
Yep.
Yeah,
all-
I mean, we
all
just
just-
discussed,
yeah.
we just discussed the big variety of things that can actually be protected with trademarks, and there's a bit of a weighing up to do when it comes to starting to build up that trademark portfolio. Sort of seeing which brand features are standalone feature and can act as a badge of origin by itself, or sometimes a few features need to be combined into one trademark, and that way they can still get protection. So that's the part where it's often really handy to get some professional advice and see what are the best chances to get your several brand features through as trademarks, and set up a strategy for you.
Yeah, a lot of people, I mean, we do these types of searches for people on a daily basis. Just, if they've got a name in mind, we can do a quick search on the register, work out whether there's give them at least some high level prospects of success. We do that, without fee, just to give them that little bit of advice, just straight up, and be able to at least guide them about, okay, what are the prospects, what should they be doing, sort of in order of priority, and letting them know when that sort of time frame can be, and what they will get in what stages.
Exactly.
That's invaluable, especially if they're set on something, pretty early on, and then they come to us and we say, got some bad news for you. There's someone with a registered trademark. They may not have heard them. That, even if they're searching out there in the market, they may not have found them. But this brand is, and sometimes it can be a large brand, has got the trademark already registered for it. They may be about to launch whatever that is, or they just haven't been able to find it on there. But at least they're going in knowing that hey, there is this other thing out there, and then they can sort of make some more inquiries and see whether that's going to be, before they get really attached to that brand or really attached to that product name or whatever it is.
Yeah.
These initial clearance searches are just so invaluable before they start trading in the market and because once they start trading, they're immediately treading on toes, or potentially treading on toes.
Yeah, and it will make it just more difficult to rebrand in case it is necessary. So, yeah, of course, we want to make sure that the best chances of success are set forward at the moment that we're starting to file trademark applications for a business.
The amount of businesses that come to us and say, "Oh, we've just got all of our branding and stuff done by a branding expert, and that was $20,000, and then we have to break the bad news to them that, there's, literally had this about 6 months ago. There were 5 registered trademarks, covering the same or similar services on the register, which is just so fraught with danger. And they had to go back and all they needed to do was, at the time when they were talking with their branding agent, was just give us a quick call, and we could run through that over the phone. It would have taken us 5 minutes,
Exactly.
Wasn't a
well, that sort of
brings
us.
Of it.
Yeah.
After spending 20 grand.
Oof.
You're right. Choosing the trademark classes.
Yeah, which is just another part that's so relevant to discuss before going into the trademark application process, and where we definitely spend some time advising our clients and making sure that you're heading into the right direction. Um, Ultimately, trademark registration only protects the products and services that are included in a trademark. So while filing the trademark application, we have to list all the goods and services that the brand will be used for. Those are divided into 45 classes, mostly for goods and for services. And yeah, it's important to choose the classes at the beginning, and even the goods and services in those classes that you actually need to protect your business and what your business provides. Too much, and it just makes the brand vulnerable down the track. Too little, and you're not getting the right protection, which might have its own issues down the track too if you need to rely on your trademark rights. So we've seen a lot of cases, I think, over the past few years too, where not the right classes were chosen at the time of filing. It can be quite confusing when you're looking into IP Australia's pick list, and some goods and services are quite alike, but they fall into different categories, like software. Software downloadable falls into one class, and then online software that's not downloadable falls into a different one. So it's good to get some advice to see which one you actually need, and make sure that's
and it's and importantly, right, once you've chosen these trademark, so IP Australia clumps goods and services into classes so that ultimately you're not sort of paying per activity, you pay per class. But frequently, well, more often than not, we find that clients will need more than one class. They'll need 2, 3, 4 sometimes, and more, all depending on what they do. But once you've filed it and got a filing date, that's it. That the trademark is set in terms of not being able to expand on the goods and services after that date. You can whittle them down. You can reduce the scope. You can delete activities. You can amend it to restrict it. So, for instance, but certain goods, but only in this sort of area, to and usually we do that to overcome any overlap with other existing trademarks on the register that might get cited in an adverse report, and that's to sort of overcome the examiner's issues. But once it's filed, you can't expand, and then it's just saving. Well, firstly, giving the maximum protection, which is what it's all about for the trademark, over all of those core goods and services activities of the business. Otherwise, they can end up doing their dough and just having to refile,
exactly.
which we want to try and avoid, and at least give them the protection, the maximum protection over all of those core activities right from the start. Measuring twice, cut once, get it done right first time.
Yeah, and even when a business is expanding overseas, generally the same classification is followed in most countries by now. So by having it done right once, it's quite easy to continue on the right path, even if you're expanding your trademark protection overseas, and have a good basis.
That leads nicely into the next one.
Oh, doing good. Think about the future of your business. Yeah, I mean, obviously, you might be at a stage where at that time you're providing just certain products and you're moving into providing services as well, or vice versa. Or maybe you're only retailing certain goods right now, but you're thinking about creating your own products that you're going to sell in your shop too. Those type of situations, we try to get a grasp of where the business is going in the next few years, just so we can incorporate that when a trademark application is prepared. If you're thinking about expanding your business in the next year or two, it's probably a good idea to add that into trademark protection at that time. It saves having to refile trademark application down the track. And as long as you're intending to,
if they're in the same classes, you may as well get those. Get those anyway now. If we're definitely going to be doing this as well, but we're not just doing them right now. But it's like we're about to launch them. then certainly that's, you know, you grab them now, and if they don't, even better if it doesn't cost you any more because they're under the same class. And there's hundreds and thousands, sometimes thousands of activities under some of these classes. So
Yeah.
you think about all the things you can, you know, everything that businesses can do. It's phenomenal how much there is, and even then, there's stuff that's not in the IP Australia pick list. And that's the other thing too. You know, I'm coming back to that last point. IP Australia makes it, you know, it looks easy and they've tried to make it easy for businesses to self-file this stuff, but you know, it's, yeah, unfortunately,
yeah, it's difficult to grasp
not
sometimes at the time of,
not as
you know,
not as
going
easy
through the
as you
pick
might.
list. Yeah, what kind
Yeah,
of consequences it might have if you forget to put something in, or maybe if you add too much in, it's not going to benefit you as well down the track. But yeah, that's where it's really important at the time to have a good look into the business and what you're planning to do. And if it's something that's far down the track, it's something that we can add. You can add to your trademark portfolio later. You can always file another trademark application after a few years to add other classes to the protection that you already have. But yeah, if it's possible to add it into the application at the time of filing, you may as well. As long
all
as
right,
it's
number 7.
in the planning.
Don't let an adverse examination report stop your progress.
Yeah. We see it a lot on the register, don't we? That a trademark examination report is issued, and that's where the application process stops, especially for the people that have self-filed an application and maybe just don't really know what to do with it once they receive that first examination report. But yeah, there's so many options to explore once a trademark has been held back by the trademarks office because of certain issues. There's such a big range of options that we can explore to try to overcome those issues, and you have quite a bit of time to attempt overcoming any of those issues. Initially, it's a 15-month deadline that's issued, and you can always request extension of time. In some cases, you can ask for deferment, which can make a trademark application go for years before you actually, to finalize any of those issues. Yeah.
There's lots of different tricks too with this, and lots of people get really they get really hung up on once they get an adverse report. And even if they talk to the examiners, sometimes, you know, they don't get the same the response than when we contact examiners all the time. And you know, most of them by name now, and we know what examiners are, you know, which examiners are more likely to be even more conservative than others about certain things. So there's definitely, you know, and also too, just negotiating with the examiners about, you know, it might be that there's just some overlapping classes of goods and services, you know, with others, and potentially removing some of those might overcome the issues with the marks. But then sometimes they're just not straight up with that information. So it's kind of like, you know, you got to ask the right questions to get the right answers sometimes. So if your clients, if anyone's sort of received an adverse examination report, don't there's limited times when we've advised clients that, that's a bummer, and you know, this one's going to be just impossible to get through, you know.
Often where there's a will, there's a way. Even if sometimes it means trademarking a different, applying for a different trademark, like the same trademark but in a different sense. But before we explore that option, there's so many others. And
sometimes too, the things that come back on the examination report, you know, and then maybe they might cite a bunch of other trademark owners, but a client's actually got more evidence of use from an, you know, earlier period of time, so they're actually able to provide that evidence of use and get the trademark through. You know, we've seen that happen a lot, and clients coming to us, and the trademark examiner didn't even mention it to them. So just don't let them know. Don't take no for an answer straight away.
No, exactly.
All right, your business is expanding overseas.
Just wanted to bring that up because once your business grows and perhaps grows out of Australia into different jurisdictions, that's again just a point of contact where it could be good to reevaluate your trademark portfolio and see whether we can apply for trademark rights overseas and expand those rights. Especially if you see that quite a few of your customers might be coming from overseas, or you're starting to invest your marketing and advertising expenditure into getting your brand awareness up overseas. It's really good for your trademark portfolio to follow the same path and start expanding that protection to other countries.
Lot of people don't realize there's no such thing as a global trademark.
Oh, if only.
Well, the problem is we would have run out of names a long time ago.
True.
If it was the case. So and this is good for lawyers on this, whose clients are looking at trading internationally. As soon as they might mention that they're going to be trading overseas, that's the point where the alarm bell. Okay, have you got a trademark in that jurisdiction? Because we know that it's all jurisdictionally based, and you have to seek protection in the country in which you wish protection. And different countries have different rules about when you can do that. Like the US, for instance, at the moment, you either have to be trading or imminently trading, and you need to be imminently about to trade, and you need to sign off on affidavit, declaration to state that that's the case. Whereas countries
and so much more difficult to maintain your trademark registration in the US too, because you continuously have to prove that you're using the brand. Every country just has such different rules and regulations when it comes to trademarks. Some are quite similar, but there's definitely some great differences. Like China, for example, which I mentioned here in the sheet too. China is actually still first to file country. So as soon as someone else files a trademark application before then it's just not available anymore. And it'll be quite difficult usually to overhaul a decision like that, which is why we do like to advise that even if you're just manufacturing your products in China, for example, or in any other country overseas, it's good to add that country to your trademark protection too, just because there are a group of people at least that are familiar with your brand. And at least in countries like China, where a lot of manufacturing happens, it's really good to get your foot in the door first.
And then there's the second issue with that, with enforcement, and if there's another entity that's Chinese based, then that's a whole minefield for another presentation. International trademark application versus direct filings.
Oh yeah, just quickly mentioning that there's two ways to file your trademark application overseas. Now, even though there's no international trademark protection per se, or an international registration, we do have the international application process, which can make it quite a bit easier to file trademark overseas if you're wanting to file that trademark in quite a few countries at the same time. So that's two options to file a trademark application overseas, either through international application process, which is the Madrid System Protocol, or directly into each country with an agent that has an address or service in that country. It depends on the situation, which one is better. So we usually go over that. Just
hard and fast rules are there with it depends on the particular trademark, how many classes they're in, and how many countries they're looking at. And we can do a cost benefit analysis, and
if there's any difficulties that are expected already before going ahead, that could be something that's important to weigh up too.
And we often find too, with the representatives that we've got in all these major countries, it's really handy to have those, those trademark attorneys just like us, and we receive these from others internationally that are looking to file in Australia, and just running just giving us the name of it and what they're generally doing, and we can give them just a quick sort of bit of advice about what's the prospects. If this is going to be really, really hard, then they might think twice about it. So it's good to have those contacts in all those jurisdictions as these things pass too. And if we're finding as well too that it's actually good, especially on those ones where we think there might be some issues, having that person that's already done those searches, that files themselves, and if there's an adverse report received, they're already all over it.
And some issues can be prevented even before applying for the trademark. Yeah,
exactly. Stitching.
It's all hands on deck, really. Yeah. All right. Control
your trademark use.
Yeah, I mean, it adds to the success of a trademark in the long run to make sure that your trademark is properly used in the marketplace. So one of those things is to show people that you're using a type of wording or logo or whatever your trademark might be as a trademark in that sense. So you're claiming the rights to the brand. So you can do that by using the TM or the R symbol. The TM while your trademark is pending or not yet filed, and the R when your trademark is registered.
So I mean, you can see from our logo on the top right, we've got the little R symbol. What you can, and so you can only use the R symbol on the trademark that is registered. You can't use it beforehand, otherwise there's some penalties for doing so.
Yeah,
under the Trademarks Act.
best to stick to the TM sign if you're still waiting for the certificate.
Yeah, and you'll notice too, just like when we're doing lots of trademark work, you'll start to notice, have a look at brands when they come up on the TV. You'll see these their TM symbol or sometimes R symbols. When you're looking for them, you'll start to notice them a lot more. And even big international brands will sometimes use the TM symbol in a certain jurisdiction because they haven't quite got their logo or trademark through yet. So yeah, it's interesting to know. I've seen it a couple of times now where I've had a look on the register as well and seen that they haven't quite got it through yet. So they're still having to use the TM.
Yeah,
symbol.
especially
F1,
yeah.
F1 does that. F1 just has the TM symbol on it. And I think they just use that globally, even though they might have registered trademarks in most of the jurisdictions. They just use a TM symbol because obviously it's just broadcasted globally in every jurisdiction around the world.
Yeah.
So and for all of the on all the trademarks being like the badges of origin for the business, right? You can use that TM symbol as soon as you start to trade with them, and that's what we encourage people. It's really just a notification to people that this is your trademark. It doesn't give you any extra rights. It just says to people, hey, this is mine. Don't copy it. Don't try and rip off my brand. Don't try and, just like the copyright symbol is. The copyright symbol does nothing more than just indicate to people that, hey, this is my copyright. Don't copy it.
Exactly. Yeah.
Because you have a copyright, and the same with the trademark. You might still have, you've still got the underlying, common law rights in the mark because you're using it as a badge of origin for the business. The TM really just says to everyone, don't copy, don't even try. And it's funny how many times that works just to make sure people that people realize that you can't just rip this off. We've got a trademark for it. As in we are using it as a trademark.
And the same goes for when your company structure changes. Perhaps if a new branch is added to the business, or one company controls the trademark, but another might hold the trademark rights as a holding company. It's important to make sure that those connections between the companies are correctly arranged too, just to make sure that your trademark can always stand upright and you can always show that the owner of the trademark and the one that controls the trademark in the marketplace are connected and it's properly licensed.
I've got a number 11 too, so let's rip through this one.
Yeah.
Enforce your trademark rights.
Yeah, well, yeah, that's an important one too. It comes hand in hand at some point while building your trademark portfolio and establishing a brand and growing a reputation into that brand. There will be issues with copycats that might come along, or some other traders that choose a similar branding just because they know that it might lift their brand up a little bit quicker. And by having that trademark portfolio and that success of your trademarks, you also have the ability to enforce those rights and take action when someone else tries to dilute your brand or take some kind of advantage of the success that you've had with your brand reputation.
Time is of the essence.
Yeah.
you got to jump on them so quickly. Don't sit on, clients shouldn't be sitting on their hands if something like that happens. And the sooner the better you can jump on it, the more likely it is that the client's rights are going to be protected, and that it's being taken so seriously. That's happened really fast. That's because the longer you leave it, the worse it gets, and the Lacey's doctrine sort of kicks in, and acquiescing to being guilty of acquiescence. We've definitely seen that happen from time to time.
Yeah, exactly. Especially with the issue of having no registered trademarks when you find out about a situation like this, and having to wait perhaps before your trademarks are registered. It can be a bit of an iffy situation sometimes.
Yep. And number 11 that I thought of, making sure that the trademarks are registered in the correct legal entities when they are filed.
Oh, yeah, that's a good one.
That's a CPD all on its own.
Yeah.
There's so many instances where people have filed it in the companies have filed things in the names of the directors personally, or by the name of the business development manager that's been put in charge of registering the trademark has gone through some third party provider that just registers the trademark instantaneously, and suddenly they've got a trademark on the register in the name of the wrong person, which can't which may not be necessarily cured by that defect may not be just cured by a transfer or an amendment to the trademark. But obviously it's all about the time and how long that takes, and making sure we can try and stitch that up. If not, I mean, the amount of times we've had to advise clients that sorry, you need to refile. It's going to be, to make sure this is going to be enforceable, which is what, at the end of the day, this is all about. Having an enforceable trademark. You don't want to get to court and the court asks you, oh, why was this trademark filed in the wrong person's name? And then, then the court says too bad. I mean, there was a very famous,
exactly.
famous case with a large brand that couldn't prove that they owned that wasn't transferred properly, and just almost like a chain of custody in a criminal case. Then sorry, the evidence gets thrown out. Sorry, the case doesn't go any further.
Yeah, a very important one too. And as soon as ownership changes, it's very important to make sure your trademarks reflect the same.
Yeah, and when businesses, this is relevant for the lawyers out there, when businesses, when there's a sale of business or a purchase of business, this is one of the things that just gets a
corporation.
It gets lost a lot with sale and purchase of business. They don't know what to do with the trademarks. They just think, oh, they'll just get transferred, and unfortunately, unless you use the magic words with the signing and and document that assignment of the intellectual property, it doesn't work under the Act. You have to make sure it's done properly in order to be able to enforce it. And just because a business has bought something else, and they're looking at the sale contract, there's they might have transferred the intellectual property or whatnot, which wasn't done by the trademarks weren't specifically mentioned by inventory, and they weren't assigned, and there wasn't a document assigning the trademarks, then potentially they could be unenforceable. So this is it's a lot more complicated than what it's than what you might think, and what it's made out to be.
Definitely.
The more and more we're in this space, we learn, the more detailed it can really be. I know we're probably getting close to the time anyway, but thanks so much today, Reed, for jumping on and doing this webinar. There's going to be the first of many for us. We're going to go deep into trademarks and talking all sorts of trademarks and updates with trademarks and new case law and all the rest. So watch the space a bit more.
Yeah, can't wait.
Thanks, everyone.